Mediation is an opportunity in your divorce case, but it's something you need to go into with your eyes wide open. You'll hear a lot of lawyers, and especially a lot of mediators, and a lot of judges even, sing the praises of mediation. But you got to think about, why are these judges so big on mediation? They're gonna say, because hey, you're in control, you get to design how you want the case to play out rather than making the judge decide. I've heard a judge describe, like, I'm carving things up with a meat cleaver, you get to use a scalpel at a mediation. And that's valid. But being realistic, the court system also has an incentive to get your case off of their desk. And so when you look at mediation, there are benefits. It compresses time. You can put weeks and months of offers, counteroffers, in front of the other side in the span of half a day or more, and sort of figure out where you're at. But you don't want to get in a situation where you feel obligated to take a deal that you don't feel good about. So mediation is a risk-free opportunity, but the split second that it feels like an obligation, and the mediators, they're trained to do this, guys. They're trained to walk in there and try to scare the shit out of you about what's going to happen if you take your case to trial. And that doesn't mean they're lying. It doesn't mean that's not true, and that it is a risk going to trial. But they're trained to do that. They're incentivized to get a resolution come hell or high water. So at the end of the day, they've successfully mediated a case. And that's fine. That's their job. We have our job. And that's to make sure that not today or tomorrow, but 6 months from now, 6 years from now, you feel good about how your case played out. That doesn't mean you won or got what you wanted or got everything you wanted. It means you're proud of who you were and the decisions you made in the process. So please don't let mediation turn into a situation where you've got to settle the case or you're being an asshole. That's not what mediation really is, but it is what a lot of people are going to try to make you feel like. So stand up for yourself, know where the line is in your mediation, use it as an opportunity. It ultimately is all upside. It really is. So work with your lawyer to make sure that you and your lawyer are on the same page, that mediation is all upside. It is not an obligation except to participate in good faith. It's not to do a deal to settle for something that is not going to be in the best interest of your children. It's not something you're going to be proud of 6 months from now or 6 years from now. Don't fall into that trap. Stand up for yourself, and we're proud to stand up for you at your mediation. So the process of mediation, when it is done effectively, it comes with a lot of preparation. Now, doing a lot of discovery and due diligence before your mediation is going to increase the cost of your divorce litigation, but you're going to be better prepared for it. You're going to be able to organize a mediation statement. You're going to be able to alert the mediator to issues in your case, which is going to empower and enable the mediator to go to the other side and, as we've discussed separately, scare the crap out of the other side about what a judge might do about what situation. Is an opportunity at mediation. So you've worked the case, you've done your due diligence, you've drafted, or your lawyer has drafted a mediation statement which summarizes the themes in the case, the evidence in the case, and what you're looking for as a result. That's going to guide the mediator's thinking. You come into the mediation, and it's not like it is on TV, guys. I have never had a mediation where everybody's in the same room. I mean, that's high drama, made for television kind of situations. You're in separate rooms, the mediator's bouncing back and forth, exchanging offers, delivering offers to the other side, or the mediator enjoys confidentiality, legal confidentiality with you and your lawyer. You can specify what can be disclosed, what can't be disclosed to the other side. So you're helping, and listen, to take full advantage of it, consider the mediator's advice. They do this all day professionally. If you want them to accept an offer or come further towards your side, consider the mediator's advice as far as what's disclosed, what isn't. Don't just keep everything confidential. But the mediator will have those discussions with you about, hey, do you want me to tell him this? Do you want me to tell him that? Do you want me to, do you have any further authorizations? So I can go ahead and say, well, what if I offered the other side 20K instead of 16? You can prepare the mediator for those types of discussions. But it can be stressful, but it's a much slower, much more relaxed process, if you will. Although it's not in a relaxing environment per se, than maybe litigation is. So the process, if it's done the right way, is all upside, is all opportunity. And even if a mediation is quote unsuccessful, I mean, it's like sex and chocolate. I mean, even when it's bad, it's good. If you have a mediation where you don't resolve the case, you have an idea of where the other side is at. You've thrown some jabs, you've taken some punches, and you've kind of felt each other out as far as our positions in the case. Maybe you reach an agreement you're comfortable with, maybe you don't, and you have a better idea of what the other side really expects out of this process. Litigation as opposed to mediation, I hesitate to say as opposed to, because typically you have an opportunity to do both. To ultimately take your case to trial. If you've gone through the entire process and you've invested what you need to invest to be as effective as possible, you've probably gone through a mediation and now you're proceeding on to trial. There are pros to trying your case, to going all the way, to having your day in court. You will never feel like you left something on the table. This comes into play a lot more in child custody cases than it does our divorces that focus more on financial assets and high net worth individuals. The risk of litigation financially may outweigh what you would be compromising on at mediation. But when it comes to your kids, when it comes to your child's safety, when it comes to what kind of people your kids are going to become, what they're going to be exposed to, that's really going to outweigh the compromises that you might be asked to make at mediation. So the pros of litigation, I mean, you really have to consider what's at stake. Is this the life and well-being of your kids? Or is this a few $100,000 or a few $1 million? If you're in mediation in a high net worth situation, maybe, hey, if I walk out of this with $3 million instead of $4 million, like you're gonna be okay. Because if you take it to trial, like who knows what it could be. We're talking about a lot of money. Going to litigation, it's a lot of power to give to the court. It is. But what you've got to consider is, how will I feel if I settle for something at mediation that I'm just never going to feel good about? Is it going to bother me for the rest of my life? Or do I have an opportunity to move on, move forward, and just be done? Am I going to be okay? If we're talking about money, let's get to where we're going to be fine. But if we're talking about kids, that's a situation where there's a big pro to having your day in court, to speaking your truth, to standing up for yourself, for standing up for your kids, and knowing, hey, I left it all on the field, trying to do what's best for my kids. So there are lots of pros to litigation, especially in child custody cases, as opposed to settling for too much at mediation. We've talked about a couple of different things, pros and cons of mediation, pros and cons of going to court and trying your case. It's really going to come down to what's at stake. I mentioned that. Is it about the kids? Is it about money? Am I trying to maximize the expected value of the dollars? Or is this something I need to feel a certain way in order to be proud of who I am? Right? So if that's the win, it's about defining the win. Or if it's, hey, I just want to minimize risk and exposure financially. That's an opportunity at mediation. You don't have to, again, mediation, you have to show up. It can be court ordered in Alabama, but you're not obligated to reach any sort of resolution. You can do both. Don't think of it like an either or. But depending on your circumstances, that's really going to dictate how aggressive you want to be. For anyone who's cost conscious when it comes to their litigation, you've got to think about what you're willing to invest to fund your representation. You've got a few grand to put into your child custody case. That's unlikely to get you all the way through a trial, especially a hotly contested one. So work with your lawyer to not only consider your strategy, but come up with a budget for your strategy. Okay, if we approach the case this way, it could cost this much. Now, what you don't want to run into, if you are thinking about that, which you should be, is you don't want to end up in a situation where you've saved $5,000 in attorney's fees, but you've agreed to something that's going to cost you $100,000 over the next 5 years, right? So that's not good math either. It's your case, it's your family, it's your kids. Whatever your situation is, work with your lawyer to determine what's important to you, and that will help you determine the proper strategy and proper approach to your divorce litigation.